We're happy to have Judge Melanie Chase joining us today as well. Both sides have 20 minutes. Mr. Foley, if you want to reserve some time for rebuttal, the clock is set for 5 minutes. It'll flash yellow. I assume everybody can see the clock. It'll flash the middle light yellow when you're into your rebuttal time. If you want something other than 5 minutes, let us know. I understand that Ms. Connor and Mr. Harrop are going to split their time, and Ms. Connor is going to go first. So with that, we'll go ahead and invite Mr. Foley to begin. This is the case of Foley versus Orange County and certain of its employees and officers. So we'll proceed. Mr. Foley, go ahead.
Good morning, Judge Orfinger, Judge Edwards, Judge Chase. We would like 5 minutes for rebuttal. Thank you. And may it please the court, I'm David, and with me is Jennifer. She's in the room, but off screen. We are the Foleys, and we appeal the trial court's ruling on immunity and the decision based solely on that ruling to dismiss our complaint with prejudice rather than with leave to amend as to all the defendants except Orange County. Our argument is that when the defendant county employees and officials prosecuted and punished us for raising birds to sell, we were injured because under the color of official and the color and coercive force of official right, they replaced the procedural safeguards of Chapter 11 of the Orange County Code with an unauthorized and inadequate alternative. Doing that violates several provisions of the state constitution, but two of those, Article 1, Section 18 and Article 8, Section 1J, say that the legislature alone decides how the county will prosecute and punish violations of its code. So this constitutional trespass forfeits immunity. And we rely on Filer, First National Bank v. Filer, Swinson v. Cahoon, Malone v. Howell, and Kalmanson v. Lockett. And for these reasons, the trial court's ruling on immunity was a legal error, and this court should reverse. The employees and officials made their defense and immunity on a motion to dismiss, and that means that they have admitted that all the allegations in our amended verified complaint are true. So that makes the question this: when they admit that they neglected their duty to prosecute and punish us for raising birds to sell with the procedures of Chapter 11 of the Orange County Code, a procedure that is authorized by the legislature, and when they admit that they instead prosecuted and punished us with the procedures of Chapter 30 of the Orange County Code, and when by these two admissions they admit that they denied us our right to full appellate review in state court, do they forfeit immunity by neglecting their ministerial and imperative duty, by usurping the authority of the legislature and the court? We're here to ask you to answer yes, and we're here to ask you to rule, as we said in our brief, when injury is alleged to directly result from a county administrative prosecution and punishment that is not authorized by ordinance or statute, the individuals responsible must answer.
Isn't that the whole idea of immunity, though? They're supposed to be immunized from suit and liability unless their conduct is essentially in bad faith or malicious or outrageous. So ordinary mistakes, even really bad mistakes, don't give rise to personal liability. I mean, you may have a claim against the county, but why should these sorts of mistakes give rise to individual liability?
Well, that is a good question. That's the primary question.
So, I mean, taking everything that you say in your complaint as true, aren't these ordinary bureaucratic decisions that political and administrative bodies make in the ordinary course of business. Sometimes they're right, sometimes they're wrong.
Sometimes,
But isn't your
I missed what
remedy?
you were saying.
I said, these sorts of decisions seem to me to be the sort of decisions that are made every day in administrative matters and it matters before city councils and county commissions and that sort of thing. And even if they're wrong, I'm having a hard time understanding how it gives rise to personal liability. The conduct doesn't seem to be outrageous or in bad faith or malicious. It may be wrong, and if it's wrong, you've got a remedy. And I'm not suggesting it's right or wrong, but I'm just suggesting that it isn't your remedy against the county, not against these individuals who don't.
I'm not sure, Judge Orfinger, how that would be. I mean, how would our remedy be against Orange County if Orange County didn't tell these defendants to do what they did? I mean, our problem, and we're in this pickle, the same pickle that you're describing with this question. What they did is not something that that the code permits. It's not something that the statute permits. And we began with those two constitutional provisions because we wanted to make it very clear that what they did is prohibited all the way to the top. We cited First National Bank v. Filer, interesting case, happened a long time ago, but the members of a school board, they voted to approve a loan to buy property for a school. And they didn't do what the statute required they do to make that a valid loan. And the court said, well, the loan's not valid and the school board doesn't have to pay it. The individual members of the school board who agreed to it, and they actually had the stamp of the school board on the documents that approved the loan. The court still said the individuals who voted to approve that loan are personally liable to repay it. So we're at your, go ahead. Did you have?
I'm sorry, you froze. You froze on my screen for just a minute, but it may have been my screen and not everybody else's. So go ahead. You were telling me about the Filer case where the individual school board members were held responsible for a loan to the school board.
That's right. And Filer is a case that, well, I have to ask you, don't you have a nice opinion. I can't remember the name of it, but it's a nice review of the history of 768-28. And I think you begin with Filer, First National Bank v. Filer. So
don't hold me responsible for anything.
So we're just, we're basing our suit on that case, not because, not for any other reason. I mean, we would not be here except that we have found law that supports our claim against these individuals personally. And as I said, our problem is Orange County, while Orange County's here, Orange County's motion to dismiss hasn't been heard. And I'm sure they're going to fight vigorously to claim that that they have immunity. And in fact, please read Judge Strobridge's order again. She doesn't say that she immunizes them because they were performing discretionary functions, but what she does do is she quotes Harlow v. Fitzgerald, which uses that language, discretionary function. And you know that if these employees are given immunity because they were performing discretionary functions, that means Orange County too will be immunized. So we really insist that you take a look at these two provisions of the state constitution. Both have been, I wouldn't say, well, the courts just haven't said too much about them. There's a case called Crary that was recently, I think in the third DCA that we noted in our brief that references Article 1, Section 18, but no court has written on Article 8, Section 1J. And that very clearly says that the county can only prosecute code violations as the statute provides. And of course, we went through this experience, and you may not think that it's a big deal, but when a violation of the code is being prosecuted in permitting, there's just no way out. You're cornered. I mean, they compare it to doing their job. We compare it to the oath ex officio. I mean, we just had nowhere that we could possibly go. We had to go through the administrative process because, as we allege, there wasn't an ordinance that prohibited what we were doing. So we couldn't seek declaratory relief. We had to go through this administrative process. But it's not an administrative process well, it's an administrative process that could have corrected the problem, but if it got it wrong, we were stuck. And I've got to turn now to you, to Judge Edwards. You recently wrote an opinion that talked about the difference between appellate review and certiorari review. That's the problem. That's the real evil. When they do forum shopping this way, when they decide they're not going to prosecute violations before a code enforcement board where you get full appellate review, and they're going to do it instead with permitting, then you're stuck with certiorari review, and you can't challenge their authority to regulate the use that they're regulating. So you can see I'm pretty excited about this. I've completely abandoned my speech, but I hope this addresses your question, Judge Ortfinger. Does it?
Yes, thank you.
Okay.
Crowley, I have a question for you. Did you appeal the ruling of the Code Enforcement Board rather than take certiorari to the circuit court?
Yes, and I believe that the order of the Code Enforcement Board is not exactly in the record, but it is attached to a motion for, I believe Ms. Lanosa filed it for judicial notice. Yes.
Right.
And if you take a look at that, what you'll see is that there's no mention of birds, there's no mention of aviculture, there's no mention of aviaries. It's it should be clear that they were just prosecuting us for having a structure that we didn't get a permit for. And that meant that we couldn't bring the aviary and aviculture issue before the appellate court. Had we been able to do that, again, we wouldn't be here. The reason we are here is because we definitely feel like this was a deliberate act of forum shopping. They wanted to make sure that they could stop us cold, and they did. It's not, I mean, if it is business as usual, I hope you take note, because there's just not the protections in permitting, in a permitting procedure that there are in a procedure that is authorized by the legislature. In fact, I mean, permitting is supposed to be entirely prospective. It's supposed to be about what you can and can't do in the future. It's not about stopping you from doing something that you're already doing. So did you want to go further?
No, that's fine on that. In terms of the individual's personal liability or personal responsibility, what should we make of the fact that at every step of the process, whether it's the zoning manager, just everybody, the courts, everybody have said all of these employees were correctly interpreting the law. And I ask you that in kind of in phase with Judge Orfinger's question about doesn't there have to be a showing that these individuals were acting maliciously or in bad faith?
Well, again, the forum shopping is about bad faith. I mean, when they decide to prosecute in permitting, rather than in a procedure that gives us all the safeguards that permitting doesn't give us, then I think there's bad faith. Yes, you're right that, and I'm gonna lean on you on your understanding of the difference between appellate review and certiorari review. Under certiorari review, I believe, Omnipoint and the cases after Omnipoint say that on certiorari review, the court can only determine whether or not the administrative body followed its own rules. Well, that just doesn't give us what we would get in under appellate review. So does that I mean, that is my answer to your question. Does that not give you a satisfactory answer?
That's fine. You can continue on.
Well, I enjoyed this. I mean, you can, I would really like to know that I've answered that question satisfactorily, because that does keep coming up. I don't have to disagree to make the argument that we're making. I mean, the argument that we're making is even when they did have the authority to interpret the code as they did, and to their decision to stop us, to make our abandonment of aviculture a condition precedent to getting a permit, that's enforcement. That's not permitting, and certiorari can't fix that. And while I have a minute, I mean, I guess I'm using up our time, but I wanted to point out, Judge Edwards, that when you did that opinion, you pointed out when the legislature removed the word certiorari from the Code Enforcement Board Act, or the predecessor to that act. And I did a little research, and it happened right at the time the Supreme Court decided Key Haven. And Key Haven is really what happened to certiorari. Key Haven is the case that said that on administrative review, you can't review constitutional questions. And I don't know whether that's the reason the legislature removed certiorari, but it certainly would have been a good motive. But I think we've made our case very clear, and I'm going to leave the rest of my time for rebuttal. Thank you.
All right, thank you, sir. Ms. Connor, I think you were going to go first.
Thank you, Your Honor. Jessica Connor on behalf of the employees. May it please the court. The trial court correctly dismissed the Foley's claims with prejudice, because everything that is alleged in their amended complaint shows that all of the employees engaged in their discretionary functions, which are completely immune from suit. All of the allegations against the individual employees surround their permitting, their decisions to deny a permit or recommend denial of a permit, and the code inspector's decision to cite the Foleys for a violation of the land use ordinances. Those are clearly, the law couldn't be clearer that the decisions to refuse to issue a permit and decisions regarding code enforcement are discretionary decisions immune from suit. And even if the decisions are incorrectly made, that doesn't take away the immunity, because mistakes are allowed to be made. In this case, there's nothing in the amended complaint that shows that there was an incorrect decision, or that the procedural dictates of Chapter 11 or Chapter 30 or 38 were not followed. The complaint alleges that the plaintiff was denied a permit under Chapter 38 and 30. There wasn't, when the plaintiff was denied a permit, there was no prosecution of the plaintiff. It was simply a denial. That the recommendation of the zoning manager to deny the permit was then reviewed by the Board of Zoning and Adjustment, and they agreed that the permit should be denied. And then the Board of County Commissioners also agreed the permit should be denied. There was no enforcement in the zoning in the Board of Zoning and Adjustment. There was no enforcement of a fine or an order to dismantle the aviaries in those proceedings. It was simply a finding by the Board of County Commissioners that the plaintiff could not get a permit to operate aviaries in a residential district. Now, the code enforcement proceeding was pursuant to Chapter 11. And under that proceeding, the Code Enforcement Board determined that the Foleys were in violation of Chapter 38 land use regulations against having aviaries or operating aviculture businesses in a residential district. So the Code Enforcement Board said, because you're in violation of Chapter 38 zoning ordinance, you must either obtain a permit to operate your aviary, or you will be subjected to a daily fine. So it was the Chapter 11 Code Enforcement proceeding where the Foleys were cited and charged with a violation of the code. It wasn't in the chapter or Chapter 38 proceeding. That was just where the board determined that the permit should be denied. So there is no incorrect application or mixing of Chapter 30 or Chapter 11. And even if there was, the employees are still entitled to immunity for those protected decisions.
Counsel, address one thing for me. The Foleys are basing their case in large part by saying that there is actually no ordinance that prohibited them from the aviculture.
That argument really doesn't make sense because that's the crux of their whole case. The crux of their argument was that the county enforced an ordinance that prohibits or interpreted their ordinances to prohibit aviaries, and they claim that's in violation of the Florida Constitution. And so whether the ordinance, they claim the ordinance doesn't prohibit aviaries, but it does, and the ordinance, the land use regulation is in the record and shows that aviculture, commercial aviculture, is a prohibited use in the R1A district. I don't know why they argue that the ordinance doesn't prohibit aviaries, or it didn't before it was amended, but it prohibits aviaries in residential districts. It does. Even if it didn't, they could have in the code enforcement proceedings, when they appealed to the circuit court, they should have made their argument that being required to get a permit to operate their aviary was in violation of the Florida Constitution, because they argue the county doesn't have the authority to regulate aviaries. For some reason, they say they did not make that argument on appeal to the Ninth Circuit from the code enforcement proceedings. I don't know why they didn't make that argument. They certainly could have made the argument that the code enforcement order requiring them to get a permit to engage in conduct they claim the county has no authority to regulate. They could have argued to the circuit court that this was in violation of the Florida Constitution, or they could have filed an injunctive relief claim in the circuit court to enjoin enforcement of the code enforcement order that required them to get a permit to operate their aviary. They did not. They now have an injunctive relief claim pending in the lower court in this case against Orange County. Why they didn't originally file that suit 10 years ago at the time of the code enforcement proceeding, they decided not to. And if they had made it timely and properly back in 2008, after the code enforcement board said they had to get a permit, then they would not have suffered any damages, because they would have been able to stay that order, get a emergency temporary injunction staying the requirement that they get a permit or dismantle their aviaries. So that they never would have had to dismantle the aviaries. They never would have incurred any fines, because it would have been stayed pending state court review over the constitutionality of the county's ordinances regulating aviculture. They simply chose not to. So these employees did nothing wrong in simply doing their jobs, which they were tasked to do as code enforcement or permitting employees. And even if they were acting, if there wasn't discretionary immunity, let's assume code enforcement and permitting is somehow operational. Well, section 768.289A says that government employees can only be liable if they acted maliciously. And simply making an incorrect decision, which there's no allegation showing it was incorrect, but simply making an incorrect decision might show negligence, but it certainly doesn't show malice. They haven't alleged that these employees instituted the code enforcement proceedings or made the permitting decisions in order to extort the plaintiff, or because of bribery or some sort of criminal intent to harm the plaintiff. That wasn't alleged. And in fact, during the hearing on the motion to dismiss, the trial court tried to elicit from Mr. Foley, what was the malicious act? What besides allegedly making an incorrect decision was the malicious act? And Mr. Foley stated, just making the incorrect decision was enough. That was their response. That's why they were not given leave to amend. They were given the opportunity to try to articulate some sort of ultimate fact that why they should be given leave to amend that would show maliciousness. And they conceded the only thing that they thought was malicious was just an incorrect decision. That's negligence. That's not maliciousness. That's not criminal intent. And when they filed their motion for rehearing of the order dismissing their claims, again, they did not articulate anything that they would have pled if given leave to amend that was different from what they already pled. So that's why the court denied the motion for rehearing, stating all they've done is re-argued what they argued at the motion to dismiss. They didn't show anything that would amount to maliciousness that would warrant allowing them to file a second amended complaint. So that's why the trial court correctly dismissed with prejudice the Foley claims. They have a remedy. They're proceeding. They have claims still pending against Orange County, and that's who they should be bringing their claims against, and in fact have brought their claims against, not these faithful public servants. They're not to be sued simply for doing their job, which they were tasked to do, and did so properly. And not a single court to date has ever said that what they did was incorrect. In fact, as your honors pointed out, every single court that has reviewed this has said the decisions that were made were proper and in line with the Orange County ordinances. So for those reasons, if your honors have no further questions, I would respectfully request that the dismissal of the Foley's claims against these individual employees be affirmed with prejudice. Thank you.
All right, thank you, ma'am. Mr. Harrop?
Yes, thank you, Your Honor. My name is Ron Harrop. May it please the court. I represent what's been described as the official defendants of the case, and these are two categories of defendants. These include the members of the Board of Zoning Adjustment, which reviewed the decision or recommendation of the zoning manager. And then I represent the Orange County Board of County Commissioners, who in turn reviewed the recommendations or decisions of the Board of Zoning Adjustment. Now, both of these bodies, whether it's the BCC, the Board of County Commissioners, or the BZA, the Board of Zoning Adjustment, are individuals, officials who sit, we would submit, in a quasi-judicial capacity. They sit as a quasi-appellate court, if you will, of the recommendations to review the recommendations and findings of the zoning manager. And as a result of that, we submit strongly that these official defendants, as we described them, are entitled to avail themselves of judicial or quasi-judicial immunity. Judicial immunity and quasi-judicial immunity are essentially the same under the case law, and we cited that case law in our brief. And I do not need to belabor the point, but the scope of judicial immunity and its brethren quasi-judicial immunity is very broad. And is a blanket which protects nearly in all circumstances both judges and people who serve officials of government in a quasi-judicial capacity, which essentially it means applying legal principles to specific fact determinations. The cases which we cited in our brief, we cited a number of cases. Perhaps the most interesting case is the case from this court in the Calamason versus Lockhart decision. Judge Lockhart was involved in that case. That was a case decided back in 2003, but in that case, it outlines the basic principle that applies here. Namely, judicial immunity or quasi-judicial immunity will apply if two simple criteria are met. There is a judicial act, and as stated by this court, there is an act within the clear jurisdiction or that is not outside the clear jurisdiction of the body that is making the judicial or quasi-judicial determination. As observed by this court in that decision, the scope of judicial discretion is extremely broad. Clearly, this was a judicial act that meets all of the tests in the Kalamansky case, and there is no reason to depart and hold otherwise, we would submit. The other case that we cite in our briefs is the Fuller versus Truncade case, first DCA case, which is a suit against the clerk of courts. That case also involves the same principles. When we look at the circumstances here, these were officials who were essentially sitting in appellate capacity, doing their job, doing what they were required to do. Now, the basic allegation here, as I understand it, is that there was some violation of the rights under the Florida Constitution under Article 4, Section 9, reserved to the Fish and Wildlife Game Commission. Well, there has never been a determination as to the interplay of local zoning regulations, land use requirements, with regard to this particular jurisdiction of the Fish Game Commission. Yes, there was a decision by Judge Dalton in the foray into federal court, but of course that is not legally binding, and that essentially was reversed by the 11th Circuit. The fact of the matter is the crux of this case, which is based to no small part on the contention that the employees and the officials violated the constitutional rights of the plaintiff in this litigation, is based nothing more than on the plaintiff's opinion. There is no case, there is no specific or clear precedent which would give us guidance. Now, that precedent may at some point come, because under count 1 against Orange County, that constitutional claim is clearly joined. And we may get, in this particular case, a decision in that regard. But this is extremely clear, we would submit. And it goes really, we think, beyond any stretch of the imagination to maintain suits against these officials in their individual capacity. It is just not permissible and appropriate. And the dismissal of this case with prejudice was appropriate, because I submit you cannot conceive under these facts, under these circumstances, as alleged in plaintiff's amended complaint, any circumstances in which a claim against the official defendants can be validly alleged. Also, we need to bear in mind a couple of other points. In this litigation, the claimants had at least 4 opportunities to prepare complaints, at least 2 in the federal court proceeding and at least 2 here. We cannot say that there has not been an opportunity for the plaintiffs to allege whatever they want to allege. And I think that's an important consideration. The other important consideration is in the May 2019 hearing in front of Judge Strobridge, she asked Mr. Foley repeatedly questions which were designed specifically to elicit the basis of the claims against the individuals, defendants in the lawsuit. I counted 16 times questions relating to that issue was posed by Judge Strobridge to the plaintiff, and no answer satisfactorily was given. And I think that's important as well.
Counsel,
Yes.
do you think it's appropriate for this court to consider that, the conversation between Judge Strobridge and Mr. Foley, when it's considering whether or not it's possible that the complaint could be amended to allege bad faith or malicious purpose?
Yeah, absolutely. Absolutely. I know of no precedent that would say a colloquy like that is inappropriate for consideration. Plus, one last point I think needs to be made. this is a situation in which after Judge Strobridge entered her order in early August of 2019, the plaintiffs filed a motion for rehearing. Now, one would ordinarily think in a motion for rehearing, you might articulate some additional reasons why additional leave to amend should be granted, why there may be some unarticulated facts or circumstances which would help sustain a claim or cause of action. Judge Strobridge ruled that there was nothing new, it was simply re-argument. So I think these are considerations. But again, let's go back, I think, to the main point. This is a case, to the extent it attempts to assert claims against the Orange County Commissioners and the Board of Zoning Adjustment, which was squarely within the scope of these officials' quasi-judicial responsibility. There is no reason that I can see that we would ever conceive of any certain facts that would warrant an amendment. So that is our submission with regard to this case. This case has had a very long and tortuous history. These issues, as counsel has pointed out, could have been raised in a declaratory judgment action filed way back in 2007 or 2008. It got sidetracked with an extensive foray into federal court, which took it all the way up to the United States Supreme Court. And it is time that the attempts to litigate, to create what I submit respectfully is a vexatious annoyance to these public servants. It is time for this litigation against these individuals to come to an end. Thank you.
All right, thank you, sir. Mr. Foley, you have about 4 minutes remaining.
Thank you. Judge Edwards, I do want to answer a question that you asked first. Is there an ordinance that prohibited what we were doing? We were raising birds at our home, in our backyard. And there is a provision in the code, as Ms. Connor said, that prohibits commercial aviculture. What it read was commercial aviculture aviary, and it assigns that descriptor with an SIC code. And the SIC code relates to the Standard Industrial Classification Code. And when you read that, every classification is based on the degree to which the use is the primary use. Also in the code is a definition for home occupation. And at the time, before any amendments had ever been made to that definition, it said any use so long as, and it listed the requirements. And then at the end, it listed 10 things that were specifically prohibited. Aviculture wasn't one of those. Raising birds wasn't one of them. So I think to have gone to court with a declaratory action on that, we would have had some trouble, because I think a court could have seen that what we were doing could have been done as a home occupation. And that's certainly what we saw. So what our complaint says is that the defendants knew that there was no ordinance that prohibited aviary or aviculture as an accessory use, as an accessory structure, or as a accessory use or home occupation. So I'm clearing that up. I don't think that any of the extraordinary writs would have been a remedy when we were when it was permitting and not code enforcement that they withheld the permit during the period that we had to come in compliance with the code enforcement order, which didn't say aviary, didn't say aviculture, didn't say anything about birds. They withheld granting the permit because they said it was an aviary. FWC told them you can't do that, and they backed off. And then at that point, they said, but still it's aviculture. And all of the evidence that they used to tell us that we couldn't have the permit came from code enforcement. This was a code enforcement action from beginning to end. It's just that they decided they were going to win, and they were going to win without the court being able to say no to a regulation of aviculture. So they put it on this track through permitting. let me talk about the quasi-judicial immunity issue. And before that, actually, the basis of our suit against, our basis of our argument on immunity. First National Bank v. Filer, Malone v. Howell, and Swenson v. Cahoon, they're very different cases on very different facts, but I think it's reasonable to ask you to think that all three of these cases applied this two-question test. Did the defendants take action that had the color and coercive force of official action, but did defendants also fail to meet the legal predicates necessary to make that authoritative or a valid official action? That's our primary argument on appeal, that our allegations fit that two-question test. And we have cited and relied upon Kalmanson v. Lockett. That case says that the outer bounds of quasi-judicial or judicial, quasi-judicial immunity are the outer bounds of the institution that a defendant represented. So that would
Mr.
mean,
Foley,
am I out? Okay,
you're out of time. I'll give you 10 seconds to wrap up.
all right. Well, we think that they do not get prosecutorial and quasi-judicial immunity because what they did, Article 1, Section 18 and 8, Section 1J say that Orange County itself cannot do. We would like you to reverse and remand. Thank you.
All right, thank you all, and I appreciate your argument. That'll be it for today, and we'll be in recess. Thank you.
Good day, everyone.